Good morning, everyone. Thank you for joining us on a wonderful Wednesday morning. My name is Dave Worthams. I am the new Director of Human Resource Policy at the Michigan Manufacturers Association, and I'm very excited to be a part of this webinar, which is my first webinar, but I think is one that will be very beneficial for those in manufacturing, particularly those who work with HR issues in manufacturing, particularly those dealing with Medical Leave Act type of issues. Joining us this morning is Mr. Jacob Swier. Jacob is the Community Outreach and Planning Specialist for the U.S. Department of Labor, Wage and Hour Division. He spent 8 years as an investigator with the division's Grand Rapids District Office, enforcing a variety of federal labor laws, including the Family Medical Leave Act, the Fair Labor Standards Act, which also deals with minimum wage and overtime. He's done a lot with H-2B and H-2A visa programs, and he's done some stuff with government contracting and prevailing wage requirements. He brings a lot of experience to this new role and has a ton of knowledge that he's willing to share with us. So make sure as we go along the way, if you have questions, please post them in the Q&A section. We'll make sure that we can get those to Jacob so that he can address those. And he will begin to share with us the details into the Family First Coronavirus Response Act, or the FFCRA. And he'll also share with us some of those recent guidances that came out about the act. So ladies and gentlemen, please help me welcome Mr. Jacob Swier.
Fantastic. Hey, thank you so much, Dave, and to Michigan Manufacturing for having me on. I'm excited to be here this morning talking about families first, and we'll get right into it. As you all know, the law was passed in March. And Dane, let's move on to the next slide here. The disclaimer that we have, it's just to let you know that this isn't supposed to be a legal opinion. It is just for general information, and let's keep moving on here because it's the requisite slide that I like to pass over. But so anyway, you folks have been dealing with Families First since about mid-March when it was signed into law. It became effective April 1st and goes through the end of 2020, December 31st. The law is comprised of two different acts, the Emergency Paid Sick Leave and the Expanded Family Medical Leave Emergency Act. There are commonalities to both provisions, but we'll talk about them independently as we move forward and give you insight into the differences and the ways the law should be administered. So next slide, please, Dane. The FFCRA requirements really come down to a few different things, whether you're a covered employer, whether you have eligible employees that are due entitlements under the law, whether they have a qualifying reason for leave, the number of weeks and hours of leave available to that individual based on those qualifying reasons, and how to calculate their pay if they are eligible and qualified. So talking about covered employers, i.e. whether you have to administer the law or not. Private employers, fewer than 500 employees are covered under the FFCRA. If you have more than 500 employees, and we'll talk about how to count those here in a moment, you are not subject to the law and not required to provide these additional entitlements to your employees. Certain businesses with fewer than 50 employees are exempt from one of the qualifying reasons under the law, and I'll get specific about that here momentarily as well. If you're a public agency, it doesn't matter how many employees you are, you're required to administer the FFCRA. Next slide. So counting employees, if you have multiple establishments, if you have some outside of the U.S., this applies to you. You do not have to count those individuals. It's folks working inside the U.S. that are subject to count. Full-time and part-time employees must be counted to see if you reach that 500 or not. Employees on leave who are counted, it's essentially if they're on your payroll, they must be counted. Temporary employees who are jointly employed, if you're working with a staffing firm, those folks need to be counted. And the count is made when your employee leave is initiated, so when they request that leave. One thing to note, if you have bona fide independent contractors that you don't have an employment relationship with, those folks are not counted. Let's move on to the next one. So your employees can take leave under the FFCRA for 6 different reasons. And I'll go through these here in detail. The first one, they're subject to a federal, state, or local quarantine or isolation order related to COVID. This applied to many people during Governor Whitmer's initial closures and isolation orders. The interesting thing in a manufacturing context is that many of you folks and many of your employees, I'm guessing, were determined to be essential. And so in that context, qualifying reason number one wouldn't apply because essential employees weren't subject to those local quarantine orders. So that was a common question that came up. 2, if they've been advised by a healthcare provider to self-quarantine related to COVID. 3, if they're experiencing COVID symptoms and seeking some sort of medical diagnosis. And reasons 4 through 6 here are really for somebody else's COVID related reason. 4 is if you're caring for somebody who is subject to a federal or local quarantine order, or has been advised by a healthcare provider to self-quarantine. 5, and let me back up, 4 can apply to folks that have underlying healthcare conditions, so they're at risk, and so their healthcare providers suggesting that you as an individual who's employed in a manufacturing setting are exposed to COVID, and thus you should be at home and under an isolation order. So 4 could apply to some of your folks. 5, if you have a son or daughter whose school is closed or their healthcare provider is closed because of a COVID reason, you would be entitled to leave. And then 6 is sort of a catch-all. If they're experiencing similar conditions specified by Health and Human Services and they haven't released any additional circumstances that would apply under that part of the law, but keep that in mind moving forward. So for small business exemption, this is where I refer to certain businesses with less than 50 employees can be exempt from one of the parts of the law. So if you have fewer than 50 employees and you have an individual who is seeking leave because their school is their son or daughter's school is closed or their child care provider is closed, you can assert a small business exemption that would not require you to administer reason number 5. You have to establish that the requirements of this type of leave would jeopardize your business viability. So there are 3 different distinct reasons that you can provide to an individual, an investigator, for example, from the Wage and Hour Division. Let's move on to the next slide, Dane, and I'll get into those 3 reasons. So you don't have to apply for a small business exemption. It's just something that you would have to establish with somebody from the Wage and Hour Division if they came and asked. And followed up on a complaint from one of your employees. And I mean, I should be clear at this point, you know, enforcement actions under the FFCRA are complaint related. So we're getting calls on our national hotline. Investigators and support staff are screening those calls. They're determining if there's a likelihood of a violation. And then they're reaching out to employers and starting those enforcement actions to determine compliance. In those situations, we're requesting correspondence and documentation through mail because we're not doing in-person enforcement actions at this point. So that's an additional complication, but sometimes employers are requesting verification of, you know, somebody's, you know, identification, or that, you know, you're an investigator from the federal government, and that's fine when we're all being flexible in the current context and trying to conduct business as best we can in the midst of this global pandemic. So if you get an email or a phone call from a wage and hour investigator, please feel free to call me with any questions that you might have or concerns, and I'm happy to walk through that process with you as well. I digressed there a little bit, but let's get back a little into the small business exemption. So if you have 50 or fewer employees and an individual from your company is requesting leave under number 5, when their child's school or child care provider is closed, if you have one of these concerns, you can qualify for this exemption. If their leave would result in an expense or financial obligation which exceeds the available business revenues that you have available, that would be a viability question that you could claim. An employee's absence would entail a substantial risk to the financial health of your company or their capabilities because of their specialized skills, knowledge of the business, or responsibilities. And if you have insufficient employees able and willing to work as a result of this leave. So those are things to keep in mind as small employers that are trying to administer these new leave entitlements.
Jacob, before we move that slide, we do have a question on how the school closures work. Question is, does school closure mean physically closed, or does that also include if there's virtual learning that is still occurring?
Good question. So it means physically closed. And so that also applies to the current context. We're in summer. You know, because your school or your employee's child's school was closed from March to June, the end of June or mid-June, the typical summer, the school district's summer period in which school is not in session would not apply. So an individual couldn't take leave for reason number 5 during the summer session, for example. So it means physically closed. All right, good question. So there's, in addition to that exemption from reason number 5 for small businesses, there's a couple different exclusions which could apply in the manufacturing context. It's doubtful that you're employing healthcare providers or emergency responders. So I'll quick go through these. If you're a manufacturer that is manufacturing equipment for these two industries, this is not applicable to you either. This is just for individuals that are employed as healthcare providers or emergency responders. They give a pretty lengthy definition of these, and happy to go through these offline. if somebody has questions about emergency responders or healthcare providers. One of the key requirements to the law is your requirement to provide notice. And it's just like any other federal or state law that has a posting requirement. The complication with FFCRA is that this law was enacted while most of your physical businesses were closed down or at least operating on a limited basis. So not all of your employees might have received notice. So they tried to be creative with this requirement. You can email it out. You can post it on your website. You can still do the physical poster as well, but ensure from a basic standpoint that your employees are aware that they have these new entitlements under federal law. So we get questions about layoffs all the time. I mean, people were laid off prior to this law becoming effective. Employers were open for a number of weeks, and then due to business operations or viability, they were required to lay people off. If you lay off employees, they are not entitled to FFCRA. They are not entitled to additional medical leave. There are other federal programs, as all of you know, that have been made available under the pandemic to respond to layoffs and unemployment, but FFCRA is not one of those. So there are many iterations of that, whether they were due leave prior to the layoff, or whether they were on leave prior to layoffs and then you restarted business, and whether they're entitled to additional leave. And those complications are, I can address, during our Q&A, or point you to some of the resources that give really good examples for those. But the basic concept here is, if you're laying off individuals from your business, they're not due FFCRA leave. You want to be careful in that context to not have, a group of employees all taking FFCRA and them being the individuals that are laid off. For example, you want to do it in a, you're laying off a whole division, or you're laying off a whole manufacturing line. You're not singling out those individuals in any context for taking FFCRA. So move on to the next slide here, and we're going to start breaking out the two parts of the law in detail here. The first one we'll go over is emergency paid sick leave. It requires 2 additional weeks of leave for COVID related reasons. And so it's in addition to any paid time off that you already provide, whether you have a sick leave program or a paid time off program, a vacation program. This leave is 2 additional weeks for those qualifying reasons that I outlined. The entitlement requires full-time and part-time employees to be paid. In a part-time employment context, you're having to do an average of the hours that they've worked over the previous 6-month period or were scheduled. For you all, when you're going through a part-time employee schedule, or a full-time employee for that matter, you're capping them at 80 hours for this 2-week period. If you have business requirements which have your folks working 50, 60 hours, and make sure that you're capping at 80 for a 2-week period. If you have part-time employees and your business structure is such that their hours fluctuate over the preceding 6 months, you want to get an average over that period to pay them what's required under the law. So for eligibility, let's go back one slide here on eligibility, Dane. For eligibility under paid sick leave, they have only to work for you for a single day to be eligible for this for this part of the law. The expanded family medical is a little bit different, but we'll go over that in a moment here. So if you have less than 500 employees and they've worked for you for a single day, they can be eligible for this COVID leave. So the qualifying reasons we went over, so I won't belabor these, but they are important to note because it determines at what rate, what percentage they should be paid. Qualifying reasons 1 through 3, when it was for their own COVID related reason, whether they're subject to the isolation order, whether they're experiencing their own symptoms or required by their healthcare provider to quarantine, those are paid at 100%. 4 through 6, so they're caring for another individual who are experiencing symptoms or subject to the leave. Reasons 5 is the school closure or child care closure. These are all paid at 2/3. So noting the reason is integral to moving forward with your correct application of the law. So duration of leave is under emergency paid is 2 weeks, up to 80 hours. Part-time employees may use the number of hours equal to the number they have worked on average over a 2-week period, and that average is taken over 6 months, as I noted. So the required rate of pay, it's their regular rate or highest applicable wage rate, the FLSA minimum wage, or the highest applicable municipal rate. The FLSA concept of regular rate, as most of you folks know, if you're in an HR context, it's their average rate over a given week. So if you have, wage increases or shift increases, if you have piece rates or production incentives, those generally need to be included for a regular rate computation. Often it's just their hourly rate. They're paid $18 an hour on 3rd shift. That's the rate that you pay emergency paid sick leave. So the 100% calculation, as we talked about, is for reasons 1 through 3. It's for somebody's own COVID related reason. They have caps under this particular part of the law for $511 a day or $5,110 total. I have not talked to anybody that is meeting those caps, but be mindful of that if you have earners on your payroll that would exceed those. Reasons 4 through 6, again, they're paid at 2/3. The cap here is at $200 a day or $2,000 in total for the 2-week period. All right, so we'll get into the expanded family medical leave now. Be mindful, this is for a single reason. It's for that reason number 5, the school closure or child care closure. If you've been familiar with administering standard FMLA, think of this as just another qualifying reason for leave, similar to your chronic condition or pregnancy. The unique thing about, or one of the principally unique thing about this qualifying reason is that it has to be paid. And it's at 2/3 of that individual's pay. So somebody could be eligible for an addition for 12 weeks. Those 12 weeks are part of that standard FMLA entitlement. So if somebody has a chronic condition and they're taking intermittent leave with you, and they've used, as of yesterday, they've used 9 weeks of their FMLA for their medical condition. And they now want to take leave because their child care providers closed for COVID-related reasons. They only have 3 weeks of leave paid at 2/3 available to them because they've already used 9 weeks of their standard FMLA entitlement. Keep that in mind. And in the manufacturing context, I know a lot of you are administering standard FMLA, especially as we move forward into the school context in late August or early September. And if those schools stay physically closed, this is something that I think a lot of you will have to grapple with, how somebody's standard FMLA use will impact their available entitlement under this new emergency family medical leave. So the eligibility is a little bit different from standard FMLA and from the initial emergency paid sick leave. They have to have worked for you for 30 calendar days. So that's bottom line, that's the difference. And those are calendar days, not business days, and they had to have been on your payroll, immediately prior to the day they would begin that sort of leave. So if you have individuals that are right on that cusp and you have questions about whether they're eligible or not, please don't hesitate to let me know. So this just really makes clear that it's a single qualifying reason. The small business exemption applies to this single qualifying reason for leave. Keep that in mind. All of the other the other 5 reasons under the family's first leave, you're still required to administer if you have less than 50 employees. But you can take a little bit of relief from knowing that you don't have to administer this additional reason here. So this distinguishes between unpaid and paid leaves under the expanded family medical. There's not a lot that really I want folks to focus on here. They under expanded family medical, the initial 2 weeks are unpaid because it is assumed that under emergency paid leave, those first 2 weeks, that part of the law covers the first 2 weeks, and it's the additional 10 that is covered by expanded family medical. This is one of the more confusing parts of the law. It comes out of a funky legislative process, but know that for reason number 5, an individual's eligible for up to 12 weeks. Those first 2 are covered under emergency paid, and the last 10 are covered under expanded family medical. So I made sure to note this earlier in an earlier slide. It's not more weeks under FMLA. You still have your 12-week block, and an individual's amount that's due to them is dependent on how many weeks that they've used under standard FMLA. So some of the resources that we have available are outlined on this last slide. I would encourage you all to visit them. I know MMA is going to post and put out this slideshow and this webinar following, and already have, I'm guessing, every one of these resources on their FFCRA or COVID resource page. Big applause to you all for having that resource out to your members. I do want to note the Families First Response Act question and answer document is by far the most accurate and up-to-date document that gets, it's updated weekly, and so questions that come in from employers and employees are responded to from policymakers at the national office and posted right on that question and answer document. Dave referenced some of the new guidance that we've gotten, and as of Monday, there's 2 additional sites on our resource page that deal with FFCRA's interaction with some of the other federal laws, FLSA paid, minimum wage and overtime, and how an hour worked, telework, interacts with, the new paid leave concepts. And so they've broken out those questions and answers, which are confusing to everybody, but are dealing with specific laws that we were already enforcing. And they've also done that with FMLA. So look for those 2 resources, specific documents that deal with how FFCRA interacts with minimum wage and overtime and interacts with standard FMLA. At this point, my portion of the presentation is complete. I'd like to open it up for any question and answers that come directly from MMA or some of our listeners on the line here.
Jacob, thank you so much for sharing your presentation with us. We do have a couple of questions that have come in, and I've got a couple as well. Let me start you out with this question. The whole calculation portion of the law kind of seems complicated. Seems kind of like calculus, which I personally wasn't very good at back in school. But could you tell us a little bit more about how that calculation works, and how does that calculation impact if someone is teleworking from home?
Okay, good question. So there are, under that question and answer document, there are specific hours worked related questions. Often they come down to, may an individual take leave for part of the day if they're working from home, especially in the context of reason number 5, if there's kids school or childcare providers closed. If we're talking about a calculation of hours worked, if they're performing work for you, it's an hour worked whether you intended it to be or not. So you're still having to deal with that in a management context. If you're allowing, the law allows for intermittent leave only under an employer's agreement. So keep that in mind. You may allow, and you're encouraged to allow, partial days for this type of leave, but you're not required to. And if your business operations don't allow for that, then you can require them to take it under a continuous block. If we're talking about specific computations for how do I come up with the regular rate, that the hourly rate that I need to pay them at, or what is 2/3 of their average hours. Traditionally people are paid a salary or a standard hourly rate. If you're in a setting where you're providing shift differentials or piece rates or production pay, that does get a little bit more complicated, but the basic premise is using their gross wages and dividing by their hours worked in a given week to come up with that average rate, and then either multiplying that by 2/3 or coming up with their average hours and multiplying that by 2/3 to come up with that 2/3 equivalent. I would love the opportunity to answer some of those specific examples if people want to reach out to me directly. And I'd encourage Dane or Dave, if you wouldn't mind putting my posting my email to your members in the Q&A or the board here, so they have that available if they want to reach out to me directly. I guess that was a little bit longer-winded example or response, but I think in this context, really, it's about coming up with an average hourly rate that is representative and an average weekly hours worked to come up with those 2/3 equivalents.
Cool. Sounds good. Thank you. And I'm quite sure our folks behind the scenes will be putting up your email here shortly if they haven't done so already. Had another question come in. It says, my company has 10 employees. I have an employee that was around someone who had a fever. He was taking her in to get a COVID-19 test. He contacted his doctor, who said he should also be tested. He contacted his supervisor and let her know. We told him not to come to work until the results of both tests came back. This took 8.5 work days. Would this still qualify as an acceptable event, even though he showed no symptoms, but his doctor said he should get tested?
Yeah, I mean, so that has the potential to qualify for 2 different qualifying reasons under the law. The 4th reason is if you're caring for an individual who is subject to a doctor's isolation order. And the 2nd reason, if you've been required by your doctor to isolate or quarantine. So you don't have to show symptoms to be eligible or have a qualifying reason under the law. I mean, that example is important because it determines whether an individual is paid at 100% or 2/3. If their original reason for going out on leave was because of caring for the individual who was subject to that quarantine order, then that initial part of the leave would be at 2/3. But if they continued on leave because they were required by a doctor's order to isolate, then that's paid at 100%.
Thank you. Other question that came in involves employees who are part of a work share program. Are those types of employees counted as an employee under the Act?
So I mean, the bottom line is that if they're on your payroll, they're counted. I would think of it as in a part-time context. You know, they're on your payroll or part-time for 20 hours a week, and they're on employer B's payroll for another 20 hours a week. Those employees have to be counted as part of the 500. You know, I don't know if we have guidance that specifically addresses work sharing, but I know that's how we've counted employees under the standard FMLA, and I would be reasonably confident that would happen under FFCRA. I would encourage that individual to reach out to me directly for more direct guidance, but that's my hunch under the current circumstance.
Cool, thank you. Another question that came in kind of goes back to how schools being physically closed or open impacts things. The question is, if a school offers face-to-face and virtual learning, and the parent elects for virtual learning, does the Act apply?
Ooh, yeah. I mean, I'm not sure. You know, these questions are dynamic and complex, and That's why they have that living question and answer document, because situations like this are going to crop up in, a month. We're going to be dealing with this as individual school districts make those choices and give parents options, decide to be physically closed and do online learning. I have not, as a parent myself, I know I was given, I think a couple times this summer provided surveys on how I wanted the school year to be administered moving forward for 2020 and 2021. I know that the governor has allowed school districts to make those decisions individually. I'm not sure what my own kids are going to be doing this fall, and so as we encounter those, I hate to say it again, but I just would encourage folks to reach out to me directly or somebody in my office, because we don't have guidance on that yet. The basic guidance is that if their school is physically closed, they can qualify for number 5.
And kind of along those questions, for junior high, high school students, those folks who are involved in band camps or sports camps that may still be going on, that start before the official start of a school year. How does that interact with the reasons established under the Act?
So I know that the question and answer document addresses summer camps, and if they were used as a child care or daycare provider in previous years. Offhand, I'm not exactly sure the answer to that. So I would have to do a little bit more research. The way that I interact with that question and answer document, I open it up and do a search function, because currently there's 99 questions that have been responded to by our national office, and guidance is given for specific examples like this. School closures, options for school closures, what constitutes a daycare provider. I know that the regulation does determine that some of those summer camps have been considered daycare providers or child care providers, but in that specific context, I'm not sure. I would encourage folks to go to that question and answer document. They are grouped by subject, but the way that I do it is I do a search function on that web page. So I do Control F, type in daycare, see how many hits come up, and then follow through the guidance in each of those to try to find guidance that would suit me. So those are things that I'd like to research for MMA and those members directly. So please don't hesitate to shoot me an email with your individual questions after the webinar.
Fantastic. Again, we'll make sure that we've got your email address posted in the question and answer section. We'll also make sure it's attached to the video, because I do believe we will have this available on our website shortly after we conclude the day. We've got about time for 1 or 2 more questions, and one that's come through kind of touches upon how long do we think this is going to go on. Do you anticipate that leaves will be extended going into 2021? Do you think that we know that the Act expires at the end of this year? Have you heard anything about Congress already looking to extend the Act into 2021, or how do we handle things when we get to the flip of the year?
Yeah, that's a good question. I mean, the bottom line is no, I don't have insight into that process. I mean, you all know as well as I do the fickle nature of our legislators, and how those things go down to the wire. I mean, we're dealing with that with an unemployment context this week, and wondering what the heck's going to happen there. So as we get into December and, vaccines or, treatments for the coronavirus are made available, maybe that extension isn't going to be needed, but that's just me, and my personal experience or expectation. Unfortunately, I don't have any insight, and hopefully, at least from an enforcement perspective, our investigators are only going to be dealing with this through the end of 2020.
Thanks, Jacob. Appreciate that. And if you did have any insight on Congress, I definitely would be looking to talk to you more often. For sure. I think the last question that we've got is just one about, I guess, a couple of the other unrelated acts, but that are COVID-related acts that impact here. If an employer has received a federal corona relief grant or a loan, or a state grant or loan that came from federal dollars, does that somehow expand the universe of people who have to now comply on the act, or if a person would be or if a company would be exempted before or exempted under the act, would they still be exempted even if they received a loan or a grant from the federal government?
Good question. I mean, the receipt of federal money for certain activities does require employees to, for example, pay prevailing wages occasionally under a Davis-Bacon related act or Service Contract Act. But in the PPP context or other grants made available for COVID, it has nothing to do with your requirement to administer the leave under the Families First. Whether you have 500 employees is legitimately the only coverage consideration. So one of the things I will add to that is last week I just did a webinar with the Small Business Association or Administration, and IRS, and we talked about the interaction between PPP, FFCRA, and how to apply for and get the reimbursements that are allowed under the act and what documentation you can request. So from your employee to provide to the IRS or Department of Health and Human Services for ensuring you get these reimbursements. I think those things are critical to understand to feeling good as an employer about administering these new federal requirements. So if you have questions on those, I'm not a IRS or SBA expert, but I have colleagues in those agencies that I'd love to refer you to, and so use me as a resource if you have questions for those, and I'll get you all to the right place.
Thank you, Jack. Appreciate that, and I think we're going to wrap it up with that last question. Definitely want to thank you, Jacob, for being a part of the webinar today, for sharing your experiences and the information that you have about the FFCRA, and would urge members, folks who are on the webinar with us today, if you have any further questions, please feel free to contact Jacob. His email address is available in the question and answer section, but if you can't see that, it is available at swier.jacob@dol.gov, and Swier is spelled S-W-I-E-R. And don't forget, we also have a great resource available for you as well on our website at mimfg.org. You can also track us down on Facebook, YouTube, Twitter. We're even on LinkedIn for those who use that that one. So definitely feel free to use any of those resources. Jacob, if you got anything else you'd like to add, please feel free to do so.
Oh, just a big thank you to Michigan Manufacturing. Look forward to continued cooperation, specifically to you, Dave, and Delaney for the opportunity, and Dane for working magic behind the scenes. So appreciate being here and look forward to working with you all and your members in any context I can support. So thank you.
Thanks, Jacob. We definitely appreciate that. For those folks who are online, don't forget we have another webinar tomorrow morning dealing with the Bostock Supreme Court case. So feel free to join us for that. That begins at 10 a.m. Tomorrow. Definitely check your emails for the link on that. Again, we're glad to be of service to you. Feel free to reach out to us anytime. Don't forget about the website, and we'll see you guys on the flip side. Thanks a lot, everybody.
Thank you.